afternoon, everybody. My name is Valerie Ferrier. I'm an employment partner here at Meister, Seelig, and Fein, and I also work in our commercial litigation group, handling all aspects of employment disputes, both on the employer side and also for executive employees. Thanks for joining me this afternoon. We're going to talk today about restrictive covenants. I get a lot of questions about these from clients across the country, and it's a dynamic area of the law with lots of changes and lots of nuances that a practitioner needs to be aware of, whether you are representing the employee or the employer. So today, we're going to talk about understanding, enforcing, and resisting restrictive covenants, depending on who you are representing, who your client is. Our learning objectives today are going to be to understand the relevant considerations for enforceability of restrictive covenants, to prepare enforceable restrictive covenants if you are writing such on behalf of your client, understanding the applicable law in the event of a dispute. How is this going to be viewed, and how can you try to draft it to make it more enforceable, or how can you resist it to make it less enforceable, and how can we strategize to overcome a dispute. So just to kind of give a quick overview, there are multiple types of restrictive covenants, multiple things that we're talking about when we use that umbrella term. The most common one that I get questions about is the non-compete, the non-competition clause. And that is a provision in a contract, typically that's given to an employee before they start with the company, either as a condition of their employment or as part of an offer letter, whereby the employee promises not to work for the employer's competitor or to start a competing business for a specific period of time after their employment ends. We also see non-solicitation clauses, whereby employees promise that they are not going to solicit other employees who currently or formerly worked for the company, as well as any clients or customers whose acquaintance they made or whose business they may have serviced while they were working for the employer. You also sometimes see no hire clauses or no poaching clauses.